That's the motion withdrawn. And as another substitute motion appears, which is to take action on this item, both the lack and menu complaints until the board table action on this item, so that both the lack and menu complaints until the board has another closed session under anticipated litigation. Okay, board discussion.
I would be really comfortable if we could get a legal opinion, because you as the president are sort of in charge here, and so it seems like when you speak, you're speaking from a legal perspective. And you may have had some legal advice, but you're not a lawyer, and I would feel more comfortable about this decision we're making if I knew that we could actually talk to a lawyer and make sure that we were doing the right thing. And
well, and I would remind the board that we did speak with Ms. Brown in closed session. That is not required. In a cure and correct, it is not required that we hold a closed session. As a matter of fact, cure and correct by its very nature is an open session item. The more a board goes into closed session over something like this, the more anxiety and concern there is.
but wasn't it about a
correct is open session.
Well, I can see why you would do that in open session, but the idea was, it was based on the fact that there was a Brown Act violation. And so we went into closed session for us to clear this up and find out, be told, was it a Brown Act violation or not? And so now other issues have been raised, and so I would feel more comfortable having some sort of legal opinion before we jump ahead with this. I don't think, I understand you want to proceed, and I understand you want to get it over with, and you want to quit talking about it so we can move forward with the business of the district, and I couldn't agree with you more. But I want to make sure that we're doing this the best way possible and most legal way possible, and not be somehow opening ourselves up to something else that we don't know we're opening ourselves up to, because we're not. So I think it would be really in our best interest to make sure that we're doing the right thing.
Okay, and let me explain to you, if we table action on this item, a couple of things that transpire. Tabling action on these complaints is, number one, the citizens can decide no action is, we're taking no action, so we're not responding to the cure correct. We did not correct.
Well, we haven't corrected yet. We're just trying to make sure that we're doing something that's legal. And we're,
okay.
And you've talked about being legal. You've talked about doing the right thing. You're talking about the public's perception of us. And I would hope that the public would look at this mess that we're in and say, I think that they need to make sure what legal ground they're on. Are they on firm ground or not? Because there could be another lawsuit out there. And when you talk about lawsuits, you're talking about the one potential one, so I'm saying if we do something wrong here, we could have another potential one, and we would have the same problems you're suggesting. So I just think waiting and making sure what we're doing is the best thing for us legally.
Okay, and again, let me explain a couple of things here, and you can, choose to accept it or not. By not correcting, the simple action of correction mitigates those lawsuits. It's finished, it's done, it's over, and we can move on. Those lawsuits from the two complainants do not go forward.
I don't think that that's correct.
Well, you can choose not to think
I know, but
okay.
You're not an attorney.
The second.
Are you an attorney?
And that isn't the point here.
Well, no, it is the point, because I feel like you're giving us.
Share with you.
I know, but you're sharing with us. You're talking about. You're sharing district business and mixed in with legal things.
Well, and you're welcome to choose a different perspective.
No, I think the district business, the cure and correct, I understand that, but then there's the legal part of it too, and I just don't think that we can. I would hope that the public, our families who send their children to our schools would want us to be careful and would trust us if we said, okay, you know, if doing the cure and correct is the best thing to do, and it's the right thing to do, and you're not jeopardizing something else, then go ahead with it. I'm sure they wouldn't mind a week or two wait to make sure we're doing something. You're not a lawyer. I mean, if you were a lawyer, I would feel a lot better about your legal opinion.
Well, as I say, you could get two lawyers to say two different things.
I know, but
the one thing that this all holds in common, though, is the fact that by correcting an action, you do not have to be concerned about proving a Brown Act violation. This is not about that, proving a Brown Act violation. That's not a mandate or requirement of this board, nor is it an interest, really, of deciding if there's guilt.
So could somebody come up with a cure, just wander up here and have a cure and correct complaint if there were no Brown Act violation? Well, I mean, could they have one now because we're taking too long with this discussion?
No, the cure, any citizen can file a cure complaint.
For any reason.
For perceived Brown Act violation. And it isn't about any legislative body proving guilt or innocence, proving that there's a Brown Act violation. We're not a court of law. The legislative body opts to make a decision to correct it or not. The action of placing those contracts back on the agenda is the correction. And that part is finished. We're done with the cure and correct, and then we can move on January 28th. It's not to discuss the merits or the employees or anything like that. It's about, do we want to correct the action in a simple process of placing those contracts back on the agenda and holding that public discussion?
I really firmly believe in making sure that the audience earns their free citrus, but at some point I think we need to move on. So what I would really like to receive is outside legal counsel, not from Ms. Cooksey, because I believe she also has a conflict of interest. So to seek outside legal counsel, have that discussed in closed session, and then bring this back in and resolve it.
And we have done that at one point with Ms. Brown coming into closed session, discussing some of the ramifications of cure and correct with us in the Brown Act.
But that was very different in that she was giving background versus a legal opinion with here's what my recommendation, then the board can take that, adjust that, or however. And what's been discussed here tonight has not been very close to what I understood her opinion to be. I think we have 5 probably very different interpretations of that. So I think we have a motion to receive legal counsel and to table this. And I think we've reached a point of diminishing returns in the conversation. And I'd suggest that we vote and move on.
Well, we have several votes to move on.
Well, and the only thing I want to add, and I hope this is on, would tabling this then invalidate both of these, because we would be beyond the 30 days for both, because the second complaint, or cure and correct, was on December 21st. So we would be obviously moving on, probably beyond January 21st.
But we've already invalidated one because we just, January 14th. I had requested that the board have legal counsel prior to this meeting because I did not believe, because I wanted legal advice around how the second complaint affected the first complaint. And that request was denied by the board president.
And what I explained to you and what I talked to Ms. Brown about is this is an open session item, and the point of cure and correct is to occur in open session, and that all questions can be asked and discussed in open session.
We were unable to.
And Ms. Brown agreed that closed session is not necessary. It's not required, and it was not necessary. So we put this in open session, and that's where we are holding it. Now, the pitfall, I will say, on tabling this action is I'd just like to say that we would have to notify employees prior to February 1st that contracts, you know, the extension might not occur. So we have to actually write a letter of notification to employees because we have a February 1st deadline. And so I'm suggesting that that's part, It's part of the February 1st deadline